My session, I would like to be like a discussion amongst the experts. You are also experts in law. So whatever question, if you feel that may have a need of elaboration or explanation or some further details, so I would feel it better that if you may ask any question, so we will take a start from that. Anyhow, a little before, the General Secretary Saab told me that about the distribution of different nature of cases, probably the participants of this session may have a need to have a knowledge about that. So in High Court, you might have also probably known to this fact that some cases are directly, without the intervention of any other authority or any other court, are directly instituted in the High Court, which is called original jurisdiction of the High Court. The original jurisdiction of the High Court is vested in High Court under Article 199 of the Constitution. Because directly an aggrieved person or any person who comes within the scope of Article 199, he may directly approach to the High Court by way of making an application. Even there is no specific form of that application, which application we call as a writ petition. So as a routine, as a rule of practice, we often take a start from the relevant facts, because these are the facts which apprise the courts that what is the issue involved in that application. So the material facts are mentioned in the application. Then comes another stage wherein we state grounds, that on what basis we are seeking relief of the court, and at the end often we mention the prayer. And prayer we ask the court that what type of writs are to be issued against the respondents. So I am sure that you might know about the kinds of writs which the prohibition or mandamus, certiorari and quo warranto, etc. So that is the simple format of the writ petition. The writ petition is heard by not a single bench, but by a division bench, comprising upon 2 judges. Another type of cases is that of which mostly come to the High Court, that is revision petitions. On civil side, we call it civil revision. Civil revision petitions are filed when a trial judge has passed a decree. Then after that decree is appealed against under section 96 of the CPC. Earlier, every judgment was to be challenged before the appellate court, that was the district judge, subject to pecuniary jurisdiction. Now you know that certain amendments have taken place in the civil procedure code. So every case which is above, which is up to the extent of 50 million rupees, now that is not triable by the civil court, but that is triable by the district judge. So from the district judge, directly an appeal is preferred before the High Court. And even before but I would not go in the previous, because now that is something about the past that is no more present in the field. So I think I would deem it appropriate to stop or here that when a decree is passed by the civil judge that is appealed against before the district judge, if original trial has been conducted by the district judge, so the appeal then is preferred before the High Court. And that appeal is called a regular first appeal, RFA, shortcut. Sometimes we also file an appeal before the High Court, which is called appeal against order, FAO. First appeal against order, FAO. When trial judge has passed an order, passed a decree, that was challenged before the appellate court. The appellate court passed a decree or an order, then a revision petition is filed before the High Court, which in abbreviated form we call it is a civil revision, simply CR. CR are disposed of by a single judge, often subject to pecuniary jurisdiction. Beyond certain limits, a pecuniary limit, then that is disposed of by division bench. So FAO, RFA, CR and repetition. Second appeal sometimes is also filed, which is called RSA, regular second appeal. That also depends upon the pecuniary jurisdiction, some to be decided by the single judge while other by the division bench, comprising upon 2 judges. So, in my view, it was the shortcut explanation of the different nature of the cases. Now, as I stated earlier before, I would like that it would be better for me that if you may ask any question, because to me it should be a session of discussion between you and me. So if you have any kind of question, because you have to build up your capacity of practice, so in the practical field, if you are facing some tough or difficult problems, always every lawyer has to face some problems. That is part of this profession, even until death. But at the moment, if you are facing something acute, something very serious in its nature, so I think it is an opportunity that you may ask some question, then I will respond. If anything was in my mind, I will try the best to explain that. So please start if anybody is having in his mind any question or any query.
Tell us something about the cause list.
Cause list.
About the motion cases, notice cases, other notice cases, and court cases, etc.
Right. Often these things are discussed by the office bearers of the association with the administration and the senior judge or the judges of the High Court, how to make that cause list. Anyhow, at the moment, at the very start of the cause list, they are fixed motion cases. Pukhto ke behuye ma sanga chorta munga ga kachapi shiwayu ya limini ki chikam hearing ki ta so lower courts ki chikala district judge ta appeal kari revision kari ago yere limini ki pe behas ho kai chida maintainable de na de substance pakeshta sa gunjaish ta sa further samad da para munasib de na de no motion ki aga fixi दाव कतीशी चे आए मजीद समात दपारा देखी सा गुंजाइश था कना नमोशन की कोशिश था पकारी बल्कि ज़ख़्म चे फुल प्रत्यारे पकारी ज़के चे बाज़ औक़ात कोर्ट माइंड दासी भी चे आगा ना एडमिट के आगा केस नो सड़े फुली प्रिपेयर्ड नहीं ब्या अक्सर केस उरांची या केस डिसमिस मीन चे उरांची no full tayari sir ratlal pakari anyhow promotion ki chakort yo point am beloshi which is enough for admission. After that case is admitted by giving a pre-admission notice or full notice. Pre-admission da which no fully admit nishi balki court ta ki sab gunjaish karashi no prior to admission adverse party ta yani respondent ta डायरेक्शन उशी चे आगते दे नोटिस उशी या दे इन्फॉर्म शी और कागा मुनासिब गड़ी न रादी शी खपलागा दी उकी डिफेंस दी उकी बेगा जजमेंट मोशन केसेस बीफी पर स्टार्ट की लेगी ورپسې به مخکې به پری اډمیشن لګېدل، کله ناکله خو اوس دلته د ترتیب لږ بدل شوی دی. ځینې کیسونه ډېر زیات زاړه شو، د ډېر وخت نه پراته دي، نو هغه که په هغه خپل ټرن راوځي او نوټس کیسز وي، اولډ کیسز وي، نو ښه یو تاسو ته لږ دا فرق وښیم. نوټس کیس او پری اډمیشن نوټس کې څه فرق دی؟ پری اډمیشن څنګه چې ما تاسو ته ویل کیس نه ایډمیټ شوی خو نوټس وشي. پری اډمیشن بیا پرایورټي بیسس باندې چونکې دا لا اډمیټ نه وي نو دا په موشن پسې عموما ورپسې سمدستي لګي. دو چې اوس ترتیب لږ بدل شوی دی، هغه به درته لږ ایکسپلین کوم وروسته. نو هغې کې چې کله ریسپونډنټ راشي هغه هم ودرېږي او پیټیشنر هم هغه خپل ارګومنټس وکړي، نو کوټ 99% کیسز هم په دې پری اډمیشن هیرینګ کې ډسپوزل کیږي، یا یې الاو کی او یا یې ډسمس کی. چرته ایکسپشنل کیسز کې بیا فولی نوټس کی او بیا هغه کې چرته ډیټیل دغه پکار وي، ارګومنټس پکار وي، هغه بیا لیټر آن بیا نوټس کیسز کې راوځي. نوټس کیسز عموما تاسو چې آر اف ای فایل کوي هغه ایز ا روټین هغه فولی اډمیټ کیږي، ځکه چې هغې کې هغه ایویډنس او هغه ټول ریکارډ کتل غواړي، د هغې ری اپریسیشن پکار وي. نو ری اپریسیشن دپاره ډیټیل هیرینګ پکار وي او بوت پارټیز اورېدل ضروري وي. نو نوټس کیسز عموما دا د کاز لیسټ اخر کې یا منځ کې وي. نو تاسو ته خو د های کورټ نن سبا به تاسو به ځئ راځئ به درته به اندازه شوي دلته ډېر زیات کیسز لګي. نو د هغې نمبر چې راځي نو یا ججان صاحبان ستړي شوي یا زموږ وکیلان هم بیا داسې اګزاس شوي چې مونږ هم د کار نیم کورټ ته ریکویسټ وکړو یاره بلکې کیس دی اوږد دی ګرانه ده، نو عموما هغه نه ډسپوزل کېږي په اسانه باندې. خو به هر صورت دیس از د ډیویژن اف د کاز لیسټ. ریویژن زیاتره دا په دې پری اډمیشن کې آر اف ای چې وي خو ظاهره خبره ده فولي نوټس وي. ریویژن کې چونکې دا وي چې هغې کې به تاسو صرف او صرف الیګلیټي پوینټ آوټ کوئ. تاسو به سیکشن 115 اف د سی پی سی کتلی وي، هغې کې مین سبسټنس دا دی چې اف دیر از جوریسډکشنل ډیفیکټ and the judgment of the lower court نو هغه ریوایزیبل وي. نو هغې کې به jurisdiction سره related means چې مطلب څه illegality court commit کړي دي. illegality چې commit کوي نو means the court has gone beyond its jurisdiction because the courts are supposed to act according to law, not act contrary to law. So that's why every illegality is related to jurisdictional defect. نو هغې کې صرف لکه appreciation of evidence نه کېږي، detail hearing نه کېږي like that of appeal. نو هغې کې صرف illegality point out کول ضروري وي. که تاسو هغې کې کامیاب شئ نو you are supposed to have succeeded in winning your case. او نوټس کې یعنی ریګولر اپیل چې کله هغه فیصله کېږي نو هغې کې هر شی کتی شي چې آیا د لوور کورټ دا ایویډنس پراپرلی اپریشیټ کړی دی او که نه دی. اوس اپریشیشن اف ایویډنس څه شی دی دا ځان یو پوره ډیټیل دی. ما ته خو سکتر صاحب نیمه ګنټه ټایم راکړی دی، غالبا چې به پوره کېدو هلی. بل تاسو وایي چې یاره اولډ کیسز هم پکې هغه لیک وي. نو اولډ کیسز دا اکثر نوټس کیسز وي، خو دې له ځان له خانه په کاجلیس کې دې دپاره ورکړي چې دا ډېر زاړه شوي، دا قابل رحم وي چې لږ دا رامخکې شي. نو هغې له بیا کاجلیس کې ځان له کیټګري ورکړي او هغه خپل کیټګري باندې لږ مخکې نن سبا لګوي.